of the Act. And, Your Honor, as a terrorist is on conviction to imprisonment for a term not exceeding 30 years, Your Honor. And this is a person who is where it is already publicly pronounced that over 500 others are wings of terrorism. Serves only the... We've already dealt with the matter of adequate notice and public notice and screened some of them. Numberless, the Office of the Director of Public Prosecution.
And I believe that once counsel on our mandate.
Very well.
So counsel should desist and persist.
Well done, Mr. Machira. Your Honor, whatever it is worth, I don't want to respond.
Yes, Mr.
Indeed.
Yes.
Your Honor, this is the objection.
Now, yes, please. Can you
The submission by the senior counsel are intended to align
the opposite side, and we will feel like
Much obliged.
and then we will generate into the exchange of words.
Your Honor, for example, you can be charged to agree with us that
I thank you, Senior Counsel. Whereas probably the Senior Counsel Bar pertinent to law. Your Honor, at this point you will note that on the question of an initial report, it says must. There's a famous, shall. As a matter of caution and very important, especially on this first count, to confirm the age of the suspect's prosecution. Now, Your Honor, if we may look at a cursory reading of the statement of facts, the persons before you cannot respond if a plea was to be taken. We have watched, as Kenyans, persons wearing the National Police uniform, vandalizing private property in the company of members of the public in Kenya. The tragedy of allowing such a charge to proceed is that even though it may be saved at the end, probably with a discontinuation or termination of the charges, prejudice will have already occurred on the persons before the court. The reading of Section 4 cannot be isolated from the definitive definition of the term terrorist act. And because we have time, limited as it is, Section 2, and I will read it, says, prejudices national security or public safety, and then proceeds to put a rider and says and. So this charge, in the particulars, cannot be left in isolation by saying committed a terrorist act. It has to go with the sub B, which states with an aim. Mental state, what we call mens rea, is very important, because the persons before you must respond to either of the three and not all. If they had to respond to all, then in the particulars of the offense, it would have captured it that way. But yes, that the persons before you, that the statement, the particulars of the offense cannot be read in isolation without the mental state, the mens rea, intended to do what? So that it says and, which is carried out with an aim, so it particularizes them in three. One is to intimidate or cause fear amongst members of the public. If I am too fast, Your Honor, you could ask me to slow down. Yes. Number two, intimidating or compelling the government or international organizations to do or refrain from any act. And lastly, destabilizing religious, political, constitutional, economic, or social institutions.
This is the mens rea.
Yes, yes. So that as they are responding, if they will, the court will find that they should respond. They need to respond to a charge which is holistic. It is inclusive of what they intended to do. Now, finally, what the statement of facts states, and if the court will be minded to also look at the other count 2 and count 3, they are extremely identical to count number 1, with the exclusion of the term committed a terrorist act. Now, if the court would be minded to entertain all 3 counts, what the persons before the court will be doing will be to suffer not even double jeopardy, and something like that. A criminal law lecturer will have to revise his manual, will be triple jeopardy. Because what it says generally is that property was damaged allegedly by the persons before you. Of great importance as I sit down, and this has not been addressed, it cannot be possible to commit acts under Porter when Article 37 exists, and the court will take judicial notice that in the charge sheet fall squarely on a date that Article 37 was applicable. And that being the case, the drafters of Porter would have stopped Section 2B and not included the proviso that I will read it for the court as it retires. Provided that an act which disrupts any services and is committed in the pursuance of a protest. In fact, Porter does not use the description of the. It foresees that such protest may not be peaceful. So that, as we have seen, allegedly there was property that was destroyed or damaged, and it continues to say, demonstration or stoppage of work shall be deemed not to be a terrorist act within the meaning of the definition, so long as the act is not intended to result in any harm referred to in A1 to 4, which is the present case. On that date, materially, the court should take judicial notice that there was a countrywide demonstration pursuant to Article 37. As the court is winding up and retiring, Your Honor, we all come from different backgrounds and we all have things we do in life. I was once told by my grandmother that even a mortician has rights. For instance, those who work in mortuaries or places or funeral homes may picket and demonstrate when their workload goes down. What I mean is that when the mortality rate of Kenyans go down, Kenyans are not dying, morticians may complain. The work of the Director of Public Prosecution is not an easy one. It is akin to that of a mortician. And there are our colleagues on that side. And any person who was urged will not talk much about it because we are being led by senior counsel, and he's my friend. It was meant to be a joke, but everyone here is serious. Today, the persons before this court, the persons who are intended to be charged, but tomorrow, they may be our heroes. I urge this court as it retires with the utmost humility, because now I'm like the EPP, I mean it. Count number 1, because we will come to discuss the other counts. As I had said on the question of jurisdiction, it is our position that on the second count and the third count, jurisdiction to deal with this matter under the CPC as Section 71. So these alleged offences were not committed within the precincts. Other courts which can deal. I know the DPP is itching to say that the Kikuyu court is not functioning. But there is another court nearby which can handle.
Referred to by Mr. Mwangi. Mr. Mwangi wants to convince you that there are two parts of that proviso that can occasionally deemed not be terrorists act within the meaning of the definition of the referred to in paragraph A, Roman 1 and Roman 4. Roman 4 is what is of our interest. He tells you that these it should be the act of protest, demonstration, or stoppage of work. That is the act which the proviso is. Is not to the banning, destruction, or anything. It's to the action that has originated. Why am I on the street? To demonstrate. I urge you to rely on the golden rule of statute interpretation. It will not lead you to arriving to the absurdity and the mischief being actuated and perpetrated by the ODPP. The golden rule the golden rule, when it's used for interpretation, would lead you to arriving at a decision that when such an interpretation would lead to unreasonable or nonsensical results, to which the DPP is inviting you to. I rest my case.
On my promise,
Yes, Your Honor. See for the strong words by counsel, especially the Wanjiru here, about nonsensical stuff. I won't respond to that because I know that decision to charge is a very solemn decision. And a lot of repercussions. And we have taken the decision bearing in mind the rest. And especially also bearing in mind the current circumstances that we are all as Kenyans are undergoing. And before I sit down, I just wish to say that there is a lot of misunderstanding on the import of the exemption.
Coming from?
just give him an opportunity to respond to any.
I don't think he has audience, Your Honor, with due respect, and we wish to object to that,
Yes, I did.
because we are now reopening the case. Fortunately, that is the rule, and the court must be bound by those rules. We can't make our own
I
rules.
understand.
Yes.
Yes, I
I
also
as much. And
I understand, Your Honor.
counsel on the to limit. And when Mr. Mashira rose on his feet, I said to him, reserve anything that you want to say, and I'm not opening up for the prosecution to make any new submission.
No, yes.
And to leave it there.
I am well guided, but I still insist that unless the court wants to make its own rules that governs proceedings, that this gentleman, the DPP, has no audience before you. And I would wish you to make a ruling on that, Your Honor. I make an application that will make a ruling on that.
Your Honor, with tremendous respect, the Law Society is here and we represent Mr. Wanjiru. We are asking.
Yes, Your Honor.
Yes,
And thank you.
not to reopen any new issues.
Yes, thank you. Thank you to the Deputy President of the LSK.
But Your Honor, until when shall we be intimidated by the
As long as you remain
Just to save time, the Deputy President LSK went into the realm of new matters. And therefore, once you go to the realm of new matters, it gives a remit to the DPP to address. But I'm not going to address anyway.
Yes.
Just a sentiment. The DPP, and that is what I was saying before I was told to say. each other with a lot of professional courtesy. This is not between us, it's not between you. The matter only affects these people that are before this court.
So no, I do not think that needs any response.
It doesn't need. That should not be allowed.
Or only that you're not.
No.
In regard to Ms. Digger
Yes.
and Peter, because we'll be making the same application,
Yes.
if we can simply proceed with those two.
Indeed, I think even for the time.
And then those two will mostly be adopted.
Good. So, the state is in agreement.
We are in agreement.
Call out the next part. Call out the next part. So for the accused persons in 068 of 2025, you may be seated. Wale ambao wameitwa kwa kesi ya Daniel kwa Raila wanaweza kutafuta mahali hapo kazini. So call the next part. Those that are remaining, please call it out.
Criminal number 70, 2025, State versus Peter Kinyanjui, alias was Sarah Wanjiko.
Yes.
They should be here.
Peter and Sarah,
Please call them. Please call them. Please, let me have the files. This is a fresh matter.
These are fresh matters.
And we are taking quorum on this one as well. Is the new council that is coming into Mr. Odinga. Yes.
Yes. DCP, Democratic. Party in coalition with several others, including those represented by Council. The Honorable Chagwa Gabi. That you are seeing state high-handedness. Whenever they hear the name regarding the child. I'm going to invite Council